our webinar. I'm Stephanie Bivens with Bivens and Associates. We're so happy that you could join us today for this important discussion about estate planning when you have young children. Obviously, estate planning is important for everybody, but when you have young children, there's special considerations and things you need to know in order to plan for best outcome if you're no longer here to protect and advocate for your children. So with that, I'm going to introduce to you our speaker today. Very pleased to introduce attorney Megan Selvey. And Megan, with that, we'll have you take it away. Oh, one note, really quick, if anybody has any questions, please feel free to submit those through the Q&A feature on this live webinar. All right, Megan, with that, take it away.
Sounds good. All right, I'm gonna bring up my slides. There we go. Okay, so today we're talking about estate planning, and we're focusing on what families who have minor children should consider. So, goals might be slightly different than families without minor children. So we're going to kind of compare and contrast. So, okay. I wanted to start with talking about what are goals for estate planning generally that any person may have. And then we're going to talk about what other things are really important to consider when you've got minor children. So common goals for estate planning for everyone. We are usually worried about having your assets delivered or distributed to whoever you want them to receive it. So, individuals or entities. We are, from the estate planning attorney perspective, always concerned about tax efficient outcomes. So depending on the asset is the plan that we've developed to move the asset at death, one that's going to result in an efficient tax payment or minimizing tax payments. We are usually concerned with avoiding probate and having conversations with clients about what is a probate proceeding and what are the pros and cons of that. I am usually putting on clients' radars to be concerned about planning for their own incapacity. So a lot of people know that assets need a destination at death, but not so common for people to think about is, planning for your own lifespan if you're unable to manage assets and you're incapacitated. So that's a huge part of planning that we always want to consider. And then we also want to try and preserve assets. So that could be for family, it could be for your own self if you need long-term care during your lifetime. So these are common goals that we're always trying to talk about with estate planning. So when we have minor children involved, we have other goals as well. So we're usually also really concerned with if minor children are going to receive the benefit of funds, who's going to be in charge, right? We can't have a 2-year-old in charge of assets, and we can't have a 17-year-old in charge of assets either. So that's an ongoing conversation with families, is trying to help them identify who's a appropriate person to manage assets. And then right below that, I have nominating a guardian. I put the word caretaker because, that's part of the conversation. So it could be an entirely different person who's in charge of taking care of the child, who's the guardian of the child in charge of making health and well-being decisions, than who's in charge of the finances. And sometimes families are pleased to hear that maybe there could be a division of labor. Maybe there's somebody who's really, really good on financial matters, and that's not necessarily the person that they want to have guardianship over a minor child. We're usually talking about trying to avoid a conservatorship for a minor child. Conservatorship is a proceeding through the court. So having a conservatorship in place can be really expensive. From my perspective as the estate planning attorney, I'm really worried about making sure that assets of my clients are not unnecessarily wasted on maybe costly court proceedings that we could have otherwise avoided through proper planning. And then we're always, again, going to be worried about tax efficient outcomes. And we're going to be considering preserving assets, probably for the benefit of minor children. So these are extra goals that we are trying to accomplish when we're doing estate planning for minor children. Okay, so how do we accomplish all of this? So what we're doing is trying to create documents for, I'm going to say, the parents, and for the purpose of this webinar, I'm just going to use terminology of parents and minor children. I fully understand that sometimes we've got other family members here in charge of minor children, grandparents, aunt and uncles, friends, things like that. But for just the purpose of this webinar, the terminology I'll use will be parents and children. So these are common documents that we're going to try and talk about with the parents to try and have a robust plan for their assets, but also their wishes for who's taking care of their children. So this slide is sort of an agenda, if you will, and these are all the things I'm going to continue to talk about through the remainder of the webinar. So powers of attorney for the parents. I'm always, always, always recommending this. So in Arizona, we've got healthcare power of attorney, mental health power of attorney, and then financial power of attorney. Sometimes we'll call this a general power of attorney. Advanced medical directives. We will also refer to this as a living will. So it's really important for anybody to put in writing, what your wishes are for your own extraordinary healthcare events. So that's that document. We're going to talk about that. Last will and testament. That is a very important document that parents of minor children need to have. It needs to be properly created, executed. Arizona has a statute and requirements for how a valid living will is executed, and people don't always get it right when they try and do it themselves. So this is a very, very important document. These three things: powers of attorney, living will, and a last will and testament. That's the bare minimum I would ever recommend to parents of minor children. That's what bare minimum they should have. Oftentimes, we're also talking about a revocable trust for the parents, and then deed work if they own real property, if that is going to go along with the trust. So this is what we're going to cover today. Okay, so let's talk about healthcare and mental health power of attorney first. So powers of attorney for parents. Powers of attorney are you nominating someone who can help you during your lifetime. So why is this important for parents of minor children? Well, it's important to have a plan for your own self, for your own health, because you have people relying on you. So you need to have a plan if something happens to you. The whole family can be affected if there's not a proper plan in place to take care of somebody if something happens. So if the parent, and I can even use myself as an example because I've got an almost 2-year-old daughter. I can't believe that that's true, but it goes by fast, guys. So if something happens to me, I need proper documents. I need proper powers of attorney so that the people I trust, so my husband or my family, can step in and make decisions without being embroiled in a court proceeding, because that's the alternative. If you don't have healthcare power of attorney and you become incapacitated, guardianship is our alternative. It's a long, slow, expensive process, and it'd be a real shame to put your family or your loved ones through that while they are also tasked with taking care of your minor children. So to me, that seems like a really bad outcome. So first and foremost, parents have to take care of themselves first, and part of that is taking care of healthcare power of attorney. So we're always going to talk to parents about your wishes for your own health care. We're going to have conversations about what kind of care you're comfortable with, long-term care, preferences for being at home, your wishes on organ donation or burial, cremation, things like that. So there are a lot of questions that come up that we need to talk about. And of course, you have to think about who you'd want to be making those decisions for yourself. So the next thing that we would talk about normally would be a living will or advanced medical directives. So that's your wishes for your own self regarding life-sustaining treatment or extraordinary medical care. This is really important for the same reason that we talked about the healthcare power of attorney. If something happens to you, you need a clear plan for family to follow, especially if they also are taking care of minor children. You don't want to embroil them in any sort of emotional dilemma trying to figure out what you would want for very serious questions like life-sustaining treatment and all of that. It's really good to have a nice, clear plan. I wanted to mention, I've got a lot of clients who are in this similar phase of life, right? Where they're parents and they have little kids. Sometimes they're still in the phase where they're thinking about having more kids. So a question that comes up is, if one was currently pregnant, does that change their wishes for their views on life-sustaining treatment during pregnancy? So I think that that's really important for someone who's still in that phase of life to consider. And so I will usually bring that up and we'll chat about that. Okay. So we also want parents to have their own financial power of attorney. I don't use all caps very frequently, guys. So it's important. It's really, 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 really important. If someone did nothing else, you know, we want them to have a really good, sturdy financial power of attorney and a really good will. This avoids conservatorship for you. Why is that important? Conservatorship is quite a process, and it's an ongoing process. So when an adult does not have a financial power of attorney, meaning they've never set their wishes for who would manage their own finances to writing, they've never nominated someone as their agent. If something happens to you and you need someone to manage your finances, the court will appoint a conservator. That conservator has ongoing responsibilities year after year to conduct accountings, file them. There's a lot of oversight from the court for good reason, right? Because someone is managing your finances, but it's quite a process. Like I said, it can be really expensive, and it can be so easily avoided by doing a financial power of attorney. So it's just a really important document that we recommend for anyone who's an adult, anyone over age 18. We see a lot of powers of attorney rejected by banks because they don't follow Arizona law when it comes to witness and notary requirements. So it's really important that this is a document drafted by an attorney, not downloaded off the internet, because we see them rejected all the time. We've covered powers of attorney. This is, you know, parents helping others help them while they're living. It's really important. And why do we care? Because we're avoiding guardianship and conservatorship proceedings while you're living. So those are through the probate court. I talk to clients all the time. I say, you know, everyone's so worried about probate after death. Probate during life is much worse. Guardianship and conservatorship proceedings during life are more time intensive, more expensive, more involved, and they can be easily avoided just by having powers of attorney. Okay, so let's talk about the estate planning side of all of this. So before we can plan for your estate, we always need to know, what does your estate consist of, right? So a lot of times when we're doing planning for families who have little kids, we're still starting in the same place as we start with everyone. We got to know what you have so we can advise you on what to do with it. So we're going to have conversations about, like, what kind of real property do you have? What kind of personal property do you have? Do you have accounts? Do you have investments? Do you have IRAs and 401ks? Do you have insurance? Do you have businesses? You know, I put on here digital assets. That's increasingly common, especially the younger the client is, it seems like more likely they're going to have some sort of digital assets. That could be like online accounts, something like a Robinhood, or crypto, or other things, points, accumulated airline and hotel that have a lot of value. So all of that is good to know about, so we can plan for it. Okay, so what are our potential options to plan for all of this? So these are potential options. This is not me advocating for all of these options, as you can see in red. So sometimes people will say that they don't need a plan. They're probably gonna consume everything they have during lifetime. Maybe that is true. Who knows? That is not a compatible plan with minor children. So when you have minor children, you've got to have a plan, because the default plan involves things that result in probably guardianship or conservatorship through the court for minor children. And we're trying to be more organized than that and have a plan that's more thought out. So you can die intestate. That means you die without a will. Again, that's not what we want. And I think anyone coming to an attorney to do their planning agrees that that's not what you want. So beneficiary designations. I get this question a lot. I've got a savings account. Why can't I just name my children as beneficiaries? You can't do that with minor children, right? Because then we're going to wind up with a conservatorship. So beneficiary designations are often going to be utilized as part of the plan, but it may be that something like an IRA winds up having a beneficiary payable to a trust where we have trust provisions for a minor child. So we may incorporate beneficiary designations, but that's not going to be our entire plan. Joint tenancy, that's like where husband and wife have everything jointly titled, so they don't really feel like they need a plan. There's issues with that. That's not sufficient, so we're going to talk about that. And then probably we're going to do something that's either going to be a last will and testament, or a combo of a last will and testament and a trust. So let's talk about all these different options. Okay, so the first thing I want to talk about is what's wrong with just owning assets as joint tenancy or jointly titled with right of survivorship. So if one person dies, so let's say mom passes away, dad owns the asset just in his name alone. So I'm going to skip down to my last bullet point here. We're relying on the surviving joint owner to then do planning. To me, that's not a good plan, because we cannot assume that someone who's just inherited things by joint tenancy, who's probably got a lot on their plate, who's probably grieving, is going to be in the headspace where they're going to be doing this planning solo. And we can't guarantee that it's going to incorporate the wishes of what two spouses would have thought through together. Other issues. So we're just, in the same sense, we're just kicking the can down the road. We're delaying the planning until the second spouse is, solely alive. When people own things as joint tenants, you're exposing the asset to either person using the asset as collateral. So, you never want to expose assets that you own to like a third joint owner who's, a brother, sister, mom, dad, something. You're exposing your asset to them being able to use it as collateral. You're exposing it to their creditors. You're giving up control. So there are a lot of issues here. So this is not our ideal type of planning that we want to rely on. So let's talk about last will and testament. So this is a really important document for parents of minor children. In Arizona, parents can nominate in writing who they would want to be the guardian of minor children. And then specifically in a last will and testament is where they would nominate a guardian for any adult child who has special needs. So we usually recommend to parents that in the last will and testament, we will do a nomination for guardian for any minor children and any future adult children who have special needs. So we are often having a conversation with parents about who is, someone in their life or the child's life, and then maybe to the extent there is no one they trust, a trusted professional. But, usually for guardianship, people have ideas for close friends or family who would serve as guardian. I like the idea of having a succession of people, so perhaps first and second choice and maybe third. I think it's always good to have a plan. So, in the event that your first choice is unable or unwilling, or they took a job in Spain and it's just not going to work out, something like that, it's good to have a succession of people. So we want to do that. As a planning document for your estate, so how does a will transfer assets? That does happen through a probate proceeding. So that's why I've mentioned along, we may be talking about a trust as part of this planning as well. And the idea is that the trust is what helps us avoid probate, if that's a goal that families have. A will also only addresses how assets move at death, and then it nominates a guardian, but it does not address like how assets are used during your lifetime for your incapacity. So those are all things that sometimes lead clients to be interested in a trust, because in a trust we can avoid probate. We can clearly state how assets would be used for parents or for benefit of minor children during incapacity, but we'll still always have a will to nominate a guardian. Okay. So first of all, just why does a trust avoid probate? So I will often encourage clients who are not familiar with trusts, who maybe feel like it's a little bit of an abstract concept that they haven't encountered before, to think of a trust like a bucket or like a suitcase. We want the assets to go into the bucket while you're alive, and then they're already in the trust. So then if you pass away, the trust document is a set of rules for how the assets get moved elsewhere. And since they're already in the trust, we don't need a court through a probate proceeding to move assets. We just rely on the rules, the trust document, to tell us where the assets go. So the continuity of ownership, the fact that the assets are owned by the trust while living and after death, and that there's a set of rules, that's what enables us to avoid the probate court proceeding. So factors that we need to talk about between attorney and clients, so attorney and parents who are setting up documents about what kind of trust would be appropriate, would be age, certainly, like ages of everyone involved. So your age and your beneficiaries' ages. So if you've got minor children, that's really important for us to know and for us to plan for. Marital status of the client, and if it's first marriage and all the children are of this marriage, or if it's second marriage and everyone's coming into it with children from prior marriages, that's really important, and that can affect the structure of the trust that the clients might be most comfortable with. Asset types and asset values also, the reason that those questions might come up and that we really care about what assets there are, that helps us identify what kind of taxes we're worried about, if income taxes and estate taxes, and also when assets pay out, if there's any sort of tax we need to be worried about a payout. So it's really important to have specific information about assets so we can do proper planning from a tax perspective. And then we always want to know about the beneficiaries who people intend to provide for. So if it's minor children, if beneficiaries have creditor issues, if they're in high liability professions, if they're not minors, if they have health or disability, and if we're thinking that those conditions are going to be resolved or long-term. That's all really important to know. Important to know if people have charitable intent, so if they want to provide for charities or organizations with their assets. And then, you know, if you have any beneficiaries who are very likely to rock the boat, you know, there's sometimes nothing I can do about that, but I'm always interested to know ahead of time if we think that's going to be the case. So when we have minor children, we're almost always, really always going to be recommending that a share for a minor child is held in some sort of sub-trust. So that means if parents create a will or if parents create a trust, whatever they leave a minor, we can't leave a minor in charge of. Otherwise, we're going to be going through court and having a conservatorship proceeding. So we can hold the minor's share in trust, and that enables us to avoid conservatorship, and it enables us to put the parents' specific wishes into practice. So we are often talking with parents about what their vision is for who would be managing funds for a minor. Until what age would that person or professional be managing funds? So I get all sorts of desired ages from parents. Some people are really comfortable with their children having control of whatever they would inherit at, you know, age 25 or, you know, relatively young 20s age. And some people have a very different vision that would be a much older age. Sometimes we can do something like at a certain age, the child can serve as a co-trustee to kind of put on training wheels for autonomy over assets. And then at a certain age, they're solely in charge of what they inherit. We can hold minor children's share in creditor protection trusts in the state of Arizona, and that can be really helpful. So I know in my case, it seems unfathomable that my 2-year-old is someday going to grow up and be married. Stephanie's laughing because her youngest daughter just got married recently, and I'm sure she's still thinks of her as a 2-year-old sometimes.
Absolutely.
But I know factually that, you know, if we're so blessed that everyone stays healthy, that someday that'll happen. And, you know, I know that a tool that we have is whatever I could leave her, I could leave in trust. It could leave whatever inheritance she would get from me could be protected from any creditors she has. It could be protected if she got married and divorced. You know, so she wouldn't lose that in the dissolution of marriage proceeding. And that kind of creditor protection that we can do through estate planning is not any kind of protection that the child could ever create for themselves through their own efforts. So that's, you know, when you inherit something from somebody, they can craft the inheritance so that creditor protection is wrapped in. But that's not something that the beneficiary can ever do on their own. So it's a really nice thing parents can do for kids if they have the foresight to do the clarity. So oftentimes that's a discussion, and I really like that idea for families, and usually people are pretty open to that. Sometimes parents come to me with a very specific vision for how their inheritance, the inheritance for children should be used, like, and give constraints on education and, you know, certain distributions and timelines. And, you know, that's an evolving conversation. I would encourage parents to, you know, have a general idea, but then be open to feedback too, because as attorneys, we sometimes are constrained by case law and public policy on the way we can draft trust for kids. You know, we can never have restrictions that violate public policy or, you know, do things like try and prevent or incentivize marriage or something like that. So there's a lot of give and take in that conversation that needs to happen. And then the good thing is parents can also think about and choose contingent beneficiaries for children, or they can choose to give their child the ability to name contingent beneficiaries through something called the power of appointment. So as an example, like I could say, at my death, I want everything to go to my daughter Ingrid, and it's in trust until age, who knows, she's 2. I can understand that this is a hard choice, but let's say age 25. That's the most popular age that clients choose. So let's say age 25. And then I can say if she's deceased and there's still money in her trust, it could go to her kids. Or it could say if she doesn't have any, it can go to my nieces. I could say if she wants to appoint the balance to somebody else, I could give her the ability to do that as well. So there's a lot of different creative things we can do with these kind of trusts. And then my very last point down here, it's really important that we coordinate these kind of trusts with payout of any tax deferred assets like IRAs or 401ks. So that's going to be a conversation as well. And the really beneficial thing is that when these payouts go to trust for minor children, we should be able to basically toll the payout until minor children reach the age of majority. So we're just further extending the tax deferment. So that can be really helpful from a net dollars perspective. So yeah, this is a helpful conversation, pretty normal conversation we would have with parents when planning for kids. All these kind of things would come up. All right, trusts need to be funded. It's really important part of the process. So when an attorney prepares a trust, I can't speak for others, but I can speak for our firm. You're going to get very, very detailed, color-coded, if you're working with me, instructions on how assets get titled or funded to a trust. That's a really important piece of it to avoid probate. So if the trust isn't funded during life, it gets funded after death with the probate proceeding, and that's not necessarily what our goal was at the beginning. So trusts need to be funded. A really good attorney is going to give you really specific instructions. So when considering a trustee, so we talked about trustees for minor children who would be in charge of inheritance up to a certain age, or maybe indefinitely, really. I thought it would be helpful to mention things a trustee is responsible to handle, because I think that can be helpful to know. So you can consider, if you're considering your brother-in-law who's a CPA, try and envision that person that you're thinking, are they going to be able to handle all these tasks? So a trustee of a trust might be in charge of, going to financial institutions and taking control of assets, like retitling them, collecting, filling out account claims forms, calling places, faxing things. All of that is really normal post-death administration. They might have to pay bills. They might have to hire help from CPAs or attorneys. They need to be willing to account for their actions, meaning give a starting balance, give a summary of all the expenses paid and all the income that's come in. They might have to get a tax ID number for subtrusts for minors or individuals with special needs. They might have to learn about income and asset limits for someone who receives a public benefit like a Medicaid or a Social Security, and be prepared to follow those rules. So these are just examples of things a trustee might have to do. So, keep it in mind when you're thinking about who you might want to choose. And then of course, if you don't have anyone that meets that description, that's a good conversation with your attorney so that we can talk about alternatives like banks and trust companies and licensed fiduciaries. All of these entities exist to help people with exactly this kind of issue when this needs to be done and there's no good candidate to do it. All right. And then when families do set up their estate plan, it's good to keep an eye on it because things change. I just chatted with the family yesterday that discovered documents that were 20 years old and everyone named was no longer living. So, you know, it's a really good idea to keep an eye on your documents and just make sure that they're current, that they still reflect what you want. It doesn't mean that every 3 years we're going to actually update them, but I like the recommendation, and I recommend to my clients at least looking at them every 3 years to make sure they still reflect your wishes. And especially when you have young kids, at the guardian nomination, that's good to keep in mind and update as appropriate as well. So if your nominated guardian moved, or they have more kids themselves than when you nominated them, and you're questioning whether that's still like a good fit, there are a lot of reasons to keep an eye on that pretty regularly. So we always recommend review when any economic or personal changes. So if you have more kids, or you start a business, or something like that, if your beneficiaries have changes in circumstances, so if you've got adult kids that get married or have their own kids, if your named trustee moves to Spain, like these are all reasons to do an estate plan review. So that's it.
Thanks, Megan. That's fantastic. Question here is, somebody said, I've heard probate takes a while to open. If they use a trust, will somebody, I guess the trustee, have access to money sooner to continue to pay for the child's needs?
Yes. Utilization of a trust should absolutely grant quicker access to funds by the nominated trustee. It should absolutely be faster than opening a probate and getting a personal representative appointed, and then getting a bank to recognize the authority of the personal representative. So I think with minor children involved, it could be really helpful to have a trust so that, oh man, every single week it's childcare, it's paying preschool, it's the pediatrician, it's Phoenix Children's Hospital, there are a lot of things that need to be paid. So it would be really good to grant whoever is going to be helping you a method that's going to be the most efficient and the quickest. So
okay. And then another quick question. You mentioned that if somebody doesn't do this type of planning and a minor child inherits, it's going to be held in something called a conservatorship account. When the child reaches adulthood at 18, does the court just turn the money over to the child at 18, or is there anything that can be done to keep an 18-year-old from getting a whole bunch of money?
Yeah, so in our office, we've done some creative brainstorming on this issue. Hey, we have ideas. So yes, when someone's approaching age 18, the parties involved, we have a statute that allows us to ask the court to bless some sort of continuing protective arrangement. I think that in the past, it's been approved for maybe a trust arrangement to continue. But again, that has to be approved by court order. So there are many, many instances, I would say like a majority of instances, where at age 18, the minor is getting control, which is probably not what the parents wanted. And I would, as a parent myself, I would not rely on the creativity or the cooperation of the parties, in a minor conservatorship to try and dream up some sort of temporary trust arrangement. I don't think that that's likely to happen, and in most cases. So I think most often a minor is going to gain control. And, in doing estate planning, Stephanie, maybe you agree, I've never had parents say, yeah, age 18, that's when I want my kid to have control. on a blue moon occasion, parents may choose age 21. But most often parents are choosing a minimum age for control in late 20s, 30s. I mean, I've had parents choose ages all the way into the 50s, so that's not for everyone, but it's up to the parent's preference. And so I don't think age 18 is the default that we really want. So
Yeah, same thing. I've never had a client say at 18 they can get it. I have had clients of 16, 17-year-old children who are very close to adulthood, who are very responsible children. I've had those parents say, oh yeah, 21, they're going to be fine.
yeah,
We're already talking about money. We're already involving them in financial conversations, etc. But to your point, every family is unique.
yeah,
I have a case right now on my desk, and it may just be helpful for somebody to hear about what happens when there isn't the planning. Unfortunately, in this instance, years ago, a woman was killed, and she had two minor children, about 4 years in age apart from each other. So her mother and father had to become the legal guardians of the children, and there was no surviving dad. And she had no estate plan in place. And so everything went to the two children to be inherited outright. And there was some wrongful death lawsuit settlement money and a large insurance policy. And recently, the older child has turned 18. And we're in the process of having to petition the court to release over $500,000 in cash to an 18-year-old. And the 18-year-old is 18, no real life experience with regard to managing assets. And there is no circumstance under which, in this scenario, we're going to be able to continue with a protective arrangement. She's not interested. And so the court won't appoint it by statute. She's competent. She's just 18. So unfortunately, the grandparents are going to, have a lot of conversation, but it's really a matter of hope for the family that she's going to use this money for her education or job skills training or housing and investing and making it last for her, to get her into a really good start in life. But in that scenario, there's no more tools in our toolkit. That we have an 18-year-old that's going to get $500,000. And when her sibling, who's 4 years younger, reaches the age of 18, we're probably going to repeat that process. So, had mom just done some simple planning, we'd have a really different outcome. So, Megan and I see these situations all the time. And when something happens and a parent passes, if there's not a good plan in place or no plan in place, we can't go back in time and put the genie back in the bottle. It is what it is. So
I also want to,
we really have to encourage people to think about it.
Yeah, same thing. I think people don't realize. So what we've just been talking about is the default, what happens when minors would come into money. So unless everyone would agree at age 18 that some sort of helpful arrangement could continue, including the minor, it's not going to happen. They're going to have control. But the default plan for who becomes the guardian of minor children can equally be as alarming. So, if, like in my case, for example, if I wanted my sister, who is in the same phase of life with minor kids, understands the obligations of childcare and preschool and all that, and how hard it is to have littles, if I didn't put that into writing, she is really far down the list for by statute for default. There are a lot of people in my I've got 4 living grandparents that would have priority before her, and that means you've got 4 living grandparents with equal priority that have to, some sort of agreement has to be reached, you know what I mean? So, that's a really important conversation that I have a lot. So it's really important if you've got preferences that they go down in writing. So,
yeah. And some people with naming guardians, just use an example, in our case, and then also naming who would be the trustee for the children. In our family's case, my mom would be great at managing the money, but she didn't live in town.
yeah,
And my husband's parents, if something happened to both my husband and I, my husband's parents lived in town. And so the kids wouldn't have had to move school. You just have to think about all of those things. So in our situation, thank goodness it didn't happen. We're both still here. My kids are old and adults now, but my in-laws would have been the guardians, but my mother would have been handling the finances, and that would have worked in our family scenario because they got along very well and have very strong ability to communicate, and I had utmost confidence that they would work together for the benefit of my 2 children. But in another family situation, if the in-laws don't know each other, your parents and your in-laws don't know each other, and you're putting them to work together, you have to think through what would this actually be like for the family. And obviously it's terrible, but and they're hard things to think about, and parents particularly don't want to think about it. But I always tell my parent clients that have young children, listen, we recognize nobody's going to do as good a job as you. So don't worry about that. Just, you've got to figure out what is the next best alternative for your children. That's your job, right? So better you figure this out than the family have to negotiate it, or worse yet, a judge who doesn't know your family, doesn't know your children, doesn't know your values, your wishes, your sentiments. A total stranger is making these really important life decisions for your children. I mean, I know I sound really dramatic when I say it like that, but that's what happens.
It is, and we see it all the time. So
yeah.
So,
planning when you've got little kids, it's like you don't have a minute to spare.
You
need to find a few minutes and do this planning. It is really important.
And I will say, I think we make the process pretty easy. So we are very respectful of people's time, and we try and accommodate busy schedules and not make it a long, drawn out process. And I'll try and always, hopefully this presentation, people can realize I'm going to give you the prompts of what to think about, and that way you can sit down with your spouse and just talk it out and then get back to me. And then I'm going to do the hard part, which is putting it all together, and then you sign it. Yeah.
You don't have to become an expert in the law. That's our job. We'll dot the I's, cross the T's. You need to tell us what your goals and objectives are, and we'll get that accomplished with the right legal documents. So, Megan, that's probably, I don't see any more questions in the Q&A. So that's probably a good stopping point for our webinar today. But if you are in Arizona and you have questions, you want your estate plan reviewed, maybe it's older, maybe it's out of state, maybe your kids are a little older, maybe you did it before you had kids, right? All of these things, we're happy to sit down, review it with you, and give you our honest feedback as to whether what you have accomplishes your goals and objectives, or whether if we're starting from scratch, or you have something and we need to make some updates to the game plan. We'll just give you our honest feedback and help you achieve your goals and plan your legacy. So you can contact our office. I think, Megan, you had the phone number on, but that's somewhere on a slide, I'm sure. And you've got our contact information. And if we can be of help and you're in Arizona, please reach out and let us know. Thank you so much for joining us today.